name is Monteverde. I'm a partner of a law firm in Caracas, Venezuela, Torres, Plaz, Araujo. Here is also my partner, Juan Domingo Alfonso. So I'm going to try to explain a little bit about arbitration in Venezuela from the past up to the present. Before I get into expressing our consideration recommendation for optimizing arbitration in Venezuela, I should clarify that Venezuela has a legal system that consists of international treaties, a constitution, and special laws that allow for the proper resolution of disputes pertaining to business matters. However, for them to be effective, the relevant institution must be perfected, as they are what enable existing legal instruments to serve the purpose for which they were created. And such perfection may solely be achieved through the reactivation of industrial activity in the country, backed mainly by foreign investment. As a general consideration, I should stress that Venezuela recognizes means of alternative dispute resolution, including mediation, conciliation, and arbitration. Along these lines, the Constitution establishes under Articles 253 and 258 the right to resort to such means, making them a fundamental prerogative directly linked to the guarantee of access to justice by those deserving justice, especially foreign business and investors. In the past, a large share of the conflicts in Venezuela were resolved through negotiation, considering to be the quickest way, producing results more prompt than by trial in our country, which may draw out for over 5 up to maybe 10 or 10 years in all stages and instances. Today, at the present, the number of arbitration cases in Venezuela has dropped substantially due to the realization and reduction of commercial activity, suggesting that conflicts and their resolution as a social issue may solely be perfected over time and with the refreshment of the economy, giving the country the necessary mobility. The development of alternative disputes mechanisms were also spurred through case law, with the publication of decision by the Constitutional Chamber of the Supreme Court, recognizing the importance of arbitration for trade as a means of less congesting traditional conflict resolution, namely the court of law. That was in the past. In Venezuela, negotiation, conciliation, arbitration were used as a means for dispute resolution. Such mechanisms are founded in the Constitution and are fundamental rights to access justice. The difference between them, as all you know, is the level of involvement that the third party, whether an arbitrator, mediator, or conciliator, is to have in the process of resolution of the dispute. Regarding domestic arbitration in Venezuela, we have a trade arbitration law enacted in 1998 at the arbitration rules of 2 centers involving the national legal community. All such instruments are adapted to the principle of arbitration, namely competence, the autonomy of the wills of the parties, the autonomy of the arbitration clause, and contain expedited procedures, including the possibility of obtaining early protective measures to guarantee the outcome of the dispute. In this sense, in October 2017, the Constitutional Chamber of the Supreme Court declared the legality of the overturning of Article 41J of the decree with the status and force law of commercial real estate leasing regulation. The Chamber found that arbitration is an inherent, fundamental, personal constitutional right, and later conclude that arbitration, as well as the judge as the Republic, have an obligation to ensure the integrity of the Constitution. 2, the imperative, inalienable, and public nature of the rules establishes in terms of commercial leasing do not prevent the party from exercise their fundamental right to exercise arbitration as a means of settling disputes arising in relation to lease agreement entered with regard to a property for commercial use, provided the arbitration is de jure. And that third rule that does not promote the development of arbitration as a means of dispute resolution, or rather, quite the opposite, prohibits it, is in conflict with the fundamental rule established in Article 253 and 258 of our Constitution. From an international point of view, regarding arbitration, Venezuela backpedaled when it denounced the ICS ID agreement due to the large number of claims brought against the nation for the numerous expropriation by the government of Presidente Hugo Chavez. The Constitution of the Bolivarian Republic of Venezuela nonetheless still provides guarantees for foreign investors, such as principle of non-discrimination, principle of free association, principle of economic freedom, and promotion of private initiative, antitrust and consideration principle, principle of non-confiscation of property, principle of free competition, and rule of law. Maybe many of you know that in June 24, 2012, Venezuela ceased to be party to the ICID Convention, which is, as you know, international autonomous institution that investors and countries receiving investment may rely on as a neutral and autonomous forum seeking to maintain the balance of the interests of the parties through arbitration. This clearly has given rise to serious legal and economical consequences as per the rule of law and international laws referring to the protection of foreign investment as well as the right to economic and corporate freedom, among which are the impossibility to have access to ICS ID for foreign investment related arbitration. However, despite all the claims filed under ICS ID, the investment promotion and protection treaties are still in full force. International bilateral agreements still in force do indeed enable investors to resort to ICS ID as a means of conflict resolution. It could be said that foreign investors frequently use this legislation to protect investment capital from the country risk of the target state income. In conclusion, unless Venezuela were to denounce not only ICS ID but also all the treaties it has entered into, the complaint under the ICS ID does not preclude the possibility that an investor could have a right to sue the state at any competent arbitration forum based on any applicable treaties. On the other hand, there is a scarce receptivity by the Venezuelan state to accession to new conventions and international treaties containing alternative conflict resolution mechanisms. Record of international claim by investors against the Venezuela state hinders the possibility of accession to investment arbitration and closes doors. Finally, our recommendation for improving legal order in Venezuela, where it's not easy, could be subscribed to treaties and conventions related to means for protection of foreign investment, support alternative dispute resolution mechanisms, foster dispute resolution with impartial third party, not depending on the state, to the extent possible, settle lost litigation and thereby reduce the legal contingency of the Venezuelan state and provide legal certainty. In my own opinion, arbitration in Venezuela at the present time, given the political circumstances currently in place that all of you are aware, may not seem as an effective tool for dispute resolutions. The reason for this First of all, lack of investment by foreign companies in the country, implying the possibility of including arbitration clauses for the settlement of disputes through arbitration. In addition to this, the hyperinflation that the country is suffering precludes subjecting dispute to arbitration in foreign currency, namely US dollar. There is no longer much interest in subjecting conflicts to arbitration, and I believe, my own opinion, besides what I already said, the reason is that most attorneys prefer to turn to the courts rather than arbitration. I believe we should start to promote arbitration as it was in the past, through forums, seminars, and maybe into the university to have or to include an elective course about arbitration. Attorneys in Venezuela at the present time rarely recommend including arbitration clause in agreements, and that needs to be changed. Thank you very much.